And now to our main conversation for tonight. On Monday, the Supreme Court will sit to consider the application by the People's Democratic Party and Mr. Emeka Hediwa asking the Apex Court to review and reverse itself in a unanimous judgment it delivered on January the 14th. The Apex Court nullified the election of Mr. Emeka Hediwa, who was the candidate of the PDP in the 2019 governorship election in Imo State. The court declared in his place Hope Uzodinma of the APC as a duly elected governor of the state. There being apprehension over the move seeking for the review, especially after the position of the Supreme Court was known over the Bayelsa state governorship seat earlier in the week, where the Apex Court says there must be an end to litigation and also that its judgment is final. So on Monday, parties in the case will appear before the court to listen to its final verdict on the matter. And so those are supporters and members of the People's Democratic Party and, of course, the supporters of the former governor, Emeka Hediwa, organized a one-day prayer meeting seeking divine intervention ahead of Monday's Supreme Court judgment review. The crowd in the numbers gathered at the Kanu Nwankwo Sports Complex in Owerri, the Imo State capital, praying that the ruling on Tuesday will favor the party in the best interest of the state. They also used the opportunity to call on the Supreme Court to reverse the judgment, describing it as erroneous and miscarriage of justice. So let's get down to business of tonight, everyone. Let's get a sense of what really are the issues. Tonight, I have a panel from our Abuja studio. Mr. Ariyo Dare Atoye is a public affairs analyst, and also Mr. Cletus Obun, a former lawmaker and a chieftain of the APC. Thank you so much, gentlemen, for coming tonight. Let me begin with you, Mr. Atoye. One would think that after the Supreme Court gave the judgment on Wednesday, about Bayelsa State, one would think that maybe the PDP or Mr. Emeka Hediwa will probably withdraw the application at the Supreme Court, considering what the Supreme Court said, that its judgment is final and there must be an end to litigations.
Thank you very much, Sheon. I think in the taxonomy of legal matters, let me permit my inference from biology. There are pre-election matters and also there are, election cases. What happened in the case of, Bayelsa was a pre-election matter. In the instant case, it is about an election petition matter that originated from our tribunal over the Imo State governorship election. And let us be clear, and I think I'm here today just to point out one thing very important. We have to be very meticulous as a people and as a nation in terms of how we look at issues. When the judgment that has been quoted, the statement of JSC Oputa, when he talks about the fallibility of the Supreme Court, if people should look at that statement carefully, he said that the Supreme Court had done this in cases in the past. It means that the Supreme Court had reviewed itself. I've heard severally that the Supreme Court cannot review its own case. No, Supreme Court can, and it had done so, even in recent cases in 1999 and in 2015. What the Supreme Court cannot do is to sit on appeal on its own judgment. There are different things, and people are modeling them up. Under Order 8, Rule 16 of the Supreme Court, the Supreme Court can review itself if there is what we call accidental slip. The Supreme Court can review its own case if there is what we call clerical error. And there is the third one. The Supreme Court can also review itself if a case of fraud, if the judgment was obtained by fraud. So there are three grounds upon which the Supreme Court of Nigeria can review a case. And Like I said,
Bring in
the
Mr.
Supreme Court
Auburn,
did
Mr.
so
Atoye.
in
Just a
2015
moment.
in the
Let me
case
bring
of
Mr. Auburn
FID.
into the conversation. Mr. Auburn, for a lot of your members in the APC will think that there are opportunities for the APC to have a good day on Monday. From what Mr. Atoye has said, what would be your reaction?
Well, let me start by telling him that first he has laid a foundation upon which the escape route for PDP has been shot, even by themselves, being an election matter. It already is time-barred by the combined effects of Section 285, sub 5, 6, and 7, which gives 180 days for trial in the tribunals, 60 days for the appeal, and 60 days for the Supreme Court. This being an election matter, not being a pre-election matter, the court now will lack jurisdiction. Beyond that, Justice Tanko Mohammed, who now sits as the CJN, was in the 5-man panel in 2009 when Justice Kasina Allo, as he then was, now late, presided over the judgment of Omehia versus Amechi, and Ogutade read the lead judgment in that case. Justice Tanko, sitting today as CJN, was in that panel. And they had this to say about the two of them, one as support and the other one as a lead judgment. Justice Ogutade said clearly that the judgment of this court is final. In some muted anger, he said, we don't have a right to sit over our own appeal or to sit on an appeal over our own decision. And Kasinalu was even more angry and said to the counsel to Omehia that if you continue the dangerous path you are treading, you are turning this court into a musical chair that can be swerved anyhow. What the court said at that point, and it is to date, 11 years after, is as valid as it was. On Monday, what I'm expecting the court to do is to give what then Justice Allo said was punitive judgment in a manner that costs will be very heavy. Indeed, before this judgment on APC, I had predicted and I had told my friends on one of the programs in one of your sister stations that we are going to have, I'm waiting for the cost implication of what the court will do to the litigants and to the counsels who will bring such a frivolous and vexatious application before it to review itself.
Okay, so Mr. Auburn, apologies. Let's take a breather and take our break. When we come back, we look at, take an inference from what happened in the Bayelsa case, whether or not it has implication on what will happen on Monday and the way forward. That's going to be next on the program, everyone. Join us again. You never can tell what is on the minds of the justices at the Supreme Court when they come into that hallowed chamber on Monday. But whatever the case may be, a lot of people are anticipating, and there is anxiety, apprehension also amidst the rank and file of politicians in Imo State and in the major political parties involved in the case. Those two men you see there are willing and wishing to lead Imo State, and I hope that the judgment will go in their favor tomorrow. My panel tonight to discuss this matter, or we've been talking about this, Mr. Daria Atoye is a public affairs analyst, and Mr. Cletus Auburn is a chieftain of the APC and a former lawmaker. Thank you so much for talking to us. Let me, in a few seconds, allow you to land on your third, because I bought in earlier on before we went on that break, Mr. Auburn. If you quickly can make that point in a few seconds so that we can get reaction from your neighbor there.
Yes, I was making the point that the Supreme Court, in its finality, and in Justice Oputa talking about the fallibility, he was indeed admitting that infallibility is a preserve of divinity. It is not a human attribute to be infallible. Yet, because of our human nature and because of the finality and the finality of the Supreme Court, it is impossible for anybody today. And that is why I find it very, very funny when you were suggesting that they could have withdrawn. Withdrawal at this point will attract even more punitive measures from the court. And continuing is as bad as being there, because the causative agent for which APC fell into the trap of joining them in that madness was clearly beyond the reach. And therefore, when you are treating the plasmodium of a mosquito It is not the same tablet you use in treating cold. So I am very aware, and I'm so sure that by Monday, the vials, the diminishing vials of PDP pause is going
Mr.
to
Auburn,
get
Mr.
more
Auburn,
and more dry.
let's
I
put some
expect the
clarity. If you're trying to break down the issue, the incident or the case in Bayelsa State is clearly different from the Imo State. Do you think that the judges that will sit on Monday don't understand these issues for you to think that the case of Bayelsa State might be melted out on the case of Imo State?
The Imo State is even more vexatious. One, the 60 days allowed by the law under Section 285 sub 5 and as applied, 5, 6, and 7, the combined effect which gives statutory days for election matters. This is an election matter, it's not a pre-election matter. The 60 days have long expired. And we are saying that by Monday, the two cases are made worse. The case of Bayelsa was a pre-election matter, so it could drag on till next year. In fact, if I had read for you what Justice Kasinalo said in 2009, he said even if you drag now till December, he was talking in July, that nothing will change about the finality of the decision. And therefore, I find it very ridiculous that PDP even went to the extent of going to other embassies to ask them to interfere. And I think that is where the Supreme Court is going to, the judges are going. And I told you here that Justice Tanko Mohammed was in that panel in 2009. And he's sitting today as the CJN. The assault on the judiciary, the insult on the judiciary, the dragging of the judiciary to foreign embassies and bringing them even to prayer grounds. The prayer of a sinful man is an
your party
abomination
also
unto God.
made comments.
What we saw in Imo State
Your
in
party
Florida
also
is
made comment and reacted to the
here.
judgment in the case of Bayelsa. But let me go to Mr. Ario Atoye. You heard what Mr. Auburn said. It does look like there might be some showdown on Monday against the PDP. What do you think?
Thank you, Sheung. I think it's very important for us to address this matter. I mean, a very, very simple way. The Supreme Court has the power to review itself that has been established in Order 8, Rule 16. Now, my brother here is talking about the fact that in terms of that the time has elapsed. No, this is about Supreme Court doing justice to its own mistakes. So there are three grounds in which the Supreme Court cannot actually overlook because it constitutes a serious danger to the future of election petition in Nigeria and our democracy. Number one is the issue of clerical error. The clerical error in the fact that PW 54, the Deputy Commissioner of Police, on oath as a witness said that he had results from 366 polling units. The Supreme Court ruled based on 388 polling units. That's a clerical error which the Supreme Court would definitely be invited to correct. Number two, there's what we call an accidental slip based on that Order 8 Rule 16. What is the accidental slip here? There are about 70 political parties that participated in that election. The Supreme Court, the results that were presented to the Supreme Court contain only that of the PDP and the APCs. And finally, another accidental slip here. Accidental slip here means that there is what we call accidental omission, which the Supreme Court ignored and which it would definitely not augur well for this to stand. It's in the issue of spread. You will see that Supreme Court has been very, very consistent on the issue of spread. The 388 polling unit, which the Supreme Court ruled in the favor of Hope Uzodinma, represent 11% of the entire polling unit in Imo State. An issue of spread, it's a verdict of the Supreme Court, which also happened in the case of Bayelsa. In delivering the judgment of Bayelsa, when the APC was denied, they said they never made a reference to any political party. They said anybody who came second that has the spread that can meet the constitutional requirement. It is an established fact.
Mr. Atoye, because of our time, let me ask you, and I'd like you to answer straight away. The question here is that the Supreme Court is not a trial court. Some of the grounds in which you're talking about, is the PDP or the Mr. Emeka here, they are not asking the Supreme Court to retry the case with some of the facts they are bringing to the table. Quickly, please.
No. It's not a retrial. It's a review. That was why I said this review will be founded on what you call it, what the Supreme Court has also initiated in its own rule, Order 8, Rule 16, accidental slip, issue of clerical error. And if the judgment was obtained by fraud, and I've told you that the issue of clerical error in terms of 388, polling unit, and the only result available to the court was in 366. Accidental slip in the fact that about 70 political parties participated. The result presented to the Supreme Court was just PDP and APC.
But Mr. Atoye, just about in 10 seconds, because we need to close the program now. Are you afraid that the kind of fine meted on some of the councils to the APC in Bayelsa State, the PDP might suffer such? Are you afraid of such?
No, you see, Sean, let me say, if it is in the wisdom of the Supreme Court to do that, nobody will question the finality of this court. They are the representative of God on earth.
All right,
and they have to
let's allow Mr. Obon, let's give him
here.
the chance to respond to what he has said, and we have just about 20 seconds for him to do that. Mr. Obon, the final word on the program tonight. How do you think this will pan out on Monday?
Well, he laid the 3 grounds, and he talked about 366 to 388. That is a difference of 22. Mathematically speaking, is 0.02% of the total number of what he's arguing about. The question is, if you add those 22 to Ihedioha and the hopeful man from royalty, will that have given victory to PDP? It will not. 22 is sufficiently insignificant, and it's not even up to 0.5, mathematically speaking. Secondly, politically speaking, and in time, jurisprudentially speaking, you are asking for a retrial, recalculation, and recalibration. There was no clerical error. There was no mathematical error. Hope Uzodinma won his election. He's a royal man. He's a hopeful man, and he has come back
we
to
have to leave it at that. I guess that's a good place to leave it. Yeah, because we are out of time. Mr. Cletus Obon, thank you so much for coming tonight. And Mr. Dare Atoye, thank you for your time, both of you, talking to us from our Abuja studio. We await the position of the Supreme Court on Monday. But that's where we leave the show tonight. Thank you so much, everyone, for watching. I'm Sean Okimale. Bye for now.